to go ahead. I'm going to get started, get a little bit of this introduction done. For those who may not know me, I'm David Miller with IEC Time Systems, and we're glad to host today's webinar. We're based in Chattanooga, Tennessee, and we have an office in Nashville as well. And we provide organizations with time, payroll, and HCM solutions, as well as fast, friendly, and professional support. So we do know your time is valuable, and we hope that you'll have at least one good takeaway or more of some practical action steps on today's topic. Just some quick housekeeping. Today's webinar is approved for the 1-hour HRCI credit. Everyone will, I thought, start out muted, cameras off, but it looks like you just do whatever you like to do on that. That's fine. Today's webinar will be recorded, and we do have a Q&A time that will be near the end. To get as many of those questions answered as possible, if you want to just go ahead and put it in the chat area, that way we'll be able to keep that copied, and then we can answer it afterwards should we not be able to get to that. And we will, of course, send people that attend today slides of this webinar. Today's topic is unemployment insurance, how COVID has affected it and your bottom line. The bullet points are the impacts of COVID-19 legislation on unemployment, how unemployment insurance is compiled, and how it affects you as an employer of record, how unemployment expenses are impacted by employment practices and termination processes, how your rate is compiled, and how much tax you'll pay on what wages. And finally, how to proactively reduce and maintain your SUI rates. Today's speaker is Curtis Upkins, Jr., and we look forward to hearing from him. I have some slides about his credentials. I'm going to go kind of pass through them quickly because they're really quite a bit, but I want you to know that about him. And so I'll pause just a little bit, move forward, but again, we'll send the slides to you, so you'll have that as well. Okay, just a little bit of last additional info. I will again send out instructions soon after the webinar so you can apply for those HRCI credits if you need them. And we'll send out responses to the chat items that may not have got addressed during this webinar. And again, those slides will be emailed to you. And now our speaker, Curtis Upkins, and we'll let him switch over. I'm going to stop sharing my screen and give him an opportunity to share his
now. Okay, thank you so much, David. I appreciate the introduction. And the thing I really appreciate more than anything else is you're sharing my obituary picture. I have selected that picture to go on my obituary when it's time for me to depart from this dear world. If you saw the picture that David presented and you see the picture on your screen, maybe I should just close out my camera so that obituary picture image will last with everybody. I look a little different today. I have my COVID beard working. So thank you, David, for the introduction, and thank you all for sponsoring this program. So let me go to my slideshow. Okay. And so what we want to talk about a little bit here today is unemployment insurance. You know, unemployment insurance is often a hidden expense for employers. For most taxable employers like ourselves, it is a quarterly tax, and we just pay that tax. oftentimes we don't realize how much we can impact, how much we pay by strategically managing our unemployment insurance tax and managing our employee disciplinary policies and separation policies. So we're going to talk about that a little bit today. Just a really quick background on myself and Savio HR Solutions. Savio HR Solutions is a full human resource unemployment compensation management organization. We were born in 1977, and we've been in the business that long. We started off strictly as an unemployment management company, was created as part of the Mississippi Hospital Association to assist not-for-profit and public hospitals with managing and reducing their expenses for unemployment insurance benefits. We were highly successful, and as we presented to different SHRM organizations, they asked if our services could expand to other industries. So now we represent clients in manufacturing, transportation, warehousing, telecommunications, electric power, healthcare, of course. So we run the full spectrum of industries that we represent. So that's a real quick background, and let's get to the meat of this topic. So I want to start with just a few key facts about unemployment insurance. Some of these things are misunderstood, especially by employees that we terminate or separate from our employment. The first thing I want to make sure that everybody understands is that unemployment is job insurance that is 100% funded by employers. The money that the government used to pay unemployment insurance benefits and the money that they use to hire and operate the unemployment insurance program is funded by your unemployment insurance taxes. It was intended to be a short-term program to support both communities and employees during economic downturn. So if a really skilled worker is separated from employment during an economic downturn, unemployment was created to ensure that they stayed in that local market area so that when times got better, you retain your skilled workforce. This is not a welfare program. You don't get unemployment insurance because you're in need. Unemployment insurance is earned by your past work experience and your work history. And the key thing that we'll stress today is that good separation management, good employment practices can significantly reduce the amount of unemployment insurance that you pay. And we'll talk through how some of that happens in just a second. So this is just a high-level overview of the unemployment insurance process. We'll get into the weeds a little bit as we move through the slides, but the first thing I want us to understand is that the process starts, the unemployment insurance process starts when the separation occurs. So an employee is separated, and with our electronic systems now of filing by telephone or filing via computer, employees don't have to go into the office. So the turnaround time for when an employee is separated and when they file a claim is extremely short now. So if you terminate them at 10 o'clock, they're probably on the telephone on that computer filing a claim at 11 o'clock. Now, once that claim is filed, the clock starts to tick on us as employers. And the unemployment insurance program have very stringent time guidelines. If you miss one of those time guidelines, then your account is subject to be charged with unemployment benefits if they're paid. So the claimant is separated. They file a claim. The unemployment agency conducts an investigation to determine first monetary eligibility, if they've worked enough to be qualified monetarily for unemployment benefits. And then once that is established, they do what they call a non-money determination. And that determination involves them receiving information from both the separated employee and from the employer. And based on that information, they determine whether or not they are non-monetarily eligible to draw benefits. The agency issues that decision. Once that decision comes out, that initial decision comes out, either party can file an appeal to the administrative process. If it is unfavorable to the employer, they have an opportunity to file an appeal. If it is unfavorable to the claimant or the past employee, then they can file an appeal to the administrative law judge. The appeal goes from the ALJ to an appeals board within the state, and once it completes exhausts all appeal opportunities through your unemployment state agency, then an individual company can appeal a decision through your state courts. High level overview. We'll get a little bit more into the details in just a second. So the first thing we talked about is monetary eligibility. So most claims are established for a 52-week period. And the data that I have on here is incorrect for Tennessee. And I'll when I submit the slides will have the correct data for Tennessee. But each claim is established for a 52-week period. The maximum number of weeks that a person can draw is 26 weeks. And the weekly benefit amount varies from a minimum to a maximum. And we'll have your actual maximum when we present this slide deck to you. So if a person does not qualify monetarily, then the claim drops. There's no other steps necessary. You as an employee is never contacted for separation information. Everything comes to a cold stop at that point. If the claimant does qualify based on past wages and you are a base period employer, meaning that earnings that they had from you were used in the calculation period, then your account can be subject to charges. Once that is determined, the agency initiates what we call a non-monetary investigation. They will send a notice to the employer to collect separation information. And I'll tell you, in Tennessee, if you do not respond in a timely manner, then your account will be charged. Let's just say that they give you 14 days to respond, and it takes you 21 days to respond. In the interim, that individual receives 3 checks. They conduct an investigation after they receive your response and determine that the person should not have drawn benefits. They're not eligible based on the separation, and they issue a disqualification. Well, because you did not respond timely, your account is still subject to charges for the 3 weeks that were paid. Now, if any subsequent payments occur after that, you would receive a non-charge, but you will be subject to charges for the benefits paid. So it's vital that we respond thoroughly and that we respond timely to those notices and requests for separation information. If we respond promptly and a decision is disqualified, then no benefits are paid. Most of our state agencies are in a very big rush to pay claims in this pandemic era. Therefore, there are no waiting periods. So the waiting period is typically used as your investigative period. So if you don't respond, they start paying immediately. And once they start paying, they do not stop paying until a disqualification happens. In some states that we operate in, the investigative process takes 3 months. So the individual could have received 13 weeks of benefits before the initial decision is issued. If we have not responded timely to stall payment, then we would be liable for those 13 weeks of benefits. Okay. The other thing, the reason that we say that it's very important to respond to those requests for information is because we have seen that the initial decision issued by the agency is more likely to stand and not be overturned as it goes through the appeal process. So as an employee, if I get a disqualification on the initial decision or at the adjudicator level, then it's less likely that the ALJ will overturn that decision and less likely that the board or the courts will overturn that decision. In Mississippi, I'll tell you that the employer's win rate for initial disqualification is about 80%. I've not seen that number for Tennessee, but I'll tell you that the average win rate for an employer at an ALJ hearing in Tennessee is about 67%, 68%. So if you start off with a disqualification, it's much more likely that you'll sustain that disqualification throughout the process. If the claim starts off allowed, then on the same terms, it is much more likely that it will continue to be paid throughout the process. So let's get that information in early. Let's get in thorough information and get the claims disqualified at the initial stage. So the separation issues that we see most are discharge and voluntary quits. So involuntary and voluntary terminations are the majority of the issues that we see. Of course, fraud has really risen during the pandemic. We have identity theft, crooks out there stealing people's identity, filing unemployment insurance claims, and collecting tons of money. But I saw a very revealing statistic about two weeks ago. I was reading about federal unemployment, and the article said that about 30% of the $600 federal weekly enhancement amount were stolen by identity thefts, and that was a total of about $66 billion. So thieves are lining their pocket. So if we would just respond promptly, if we react promptly, we can definitely minimize both fraud claims also. So that was a little aside. So let's get back to the discharge. It's much more likely that you will win your case in an involuntary separation if you as an employer follow your own policies. We put policies and procedures in place for employees to follow, but the law holds us responsible for abiding by our own policies also. I cannot tell you how many times that I've been in an unemployment hearing, and in one situation in a circuit court case where the judge asked the supervisor to recite the policy in which the employee was being terminated for, and they could not. The legal system expects the employer to know more about their own rules and regulations than they do employees. So if an employee does not know, that is a huge knock against you. Set expectations for your employees, and then once those expectations are set, then we follow up. I have a big thing that's called inspect what you expect. That's part of your performance management process. So if you set expectations, don't wait to the end of the year to tell the employee that they have been failing to reach the standard of performance that you expect, and then terminate them for job performance without warning. Fully investigate all issues. And this is a problem because a lot of time an employee will come to HR, they'll come to management and say, hey, look, I want to tell you something, but I really don't want you to do anything about it. I just want you to know that Curtis has been harassing me. He's been criticizing me. He's been cursing me out. I don't want you to do anything to Curtis. I don't want you to want him to lose his job, but I just want the stuff to stop. So as a concerned leader or as a concerned HR person, I go in and I ask everybody around the person who made the report, have you seen Curtis doing this? Have you heard him doing this? And then when I get all the information I need to terminate Curtis, I fire him, and I forget to ask Curtis. So if I include Curtis in the investigation, he may say, hey, look, we kid around like that all the time. She cursed me out as much as I curse her out. So I thought it was a friendly banter that we all engaged in. If I knew it was wrong, if I knew it was upsetting her, I would have cut it out a long time ago, but because she continued, I continued. Sometimes if we fail to do a complete investigation, we miss that piece of information. But that's the kind of information that will come out if you go into the legal process. Documentation is key for employees. It's your lifeblood. It's your saving grace. So do it often, do it thoroughly, do it completely. Our rule is that what is uttered should be written, and what is written should be uttered. So if I am going to give an employee a verbal warning, I'm also going to write it down and let them know that this is only a verbal warning, but it will be put into your file as a verbal warning. And if you want a copy, you can have a copy. You know, as HR people, we sometimes have a problem about giving employees copies of documents. But if I write you up, you can have a copy of that documentation, because my intent in writing you up is to improve the behavior. It is not punitive. I'm not writing you up to fire you. I'm telling you that you have been deficient in this particular area. We need to correct it. This is how we do it. And you can have a copy of that. Look at it early and often. And when you see yourself straying away from the norm or straying away from standard performance or behavior, correct it. So that's the rule. What is uttered should be written, and what is written should be uttered. I would never just pass a written warning to an employee and say, here, take this, read it. This is your second warning. We should talk through it and talk through how we correct it. Timely terminate employees. I work in the healthcare field for a long, long time, and we have certification inspections, and we have all type of legal stuff that we have to abide by. And sometimes if we're expected an inspection, if we have an inspection coming up and we're trying to get ready for that inspection, we have an employee who violates a policy or procedure that should get them terminated. And I've had managers come to me and say, look, I know she's supposed to get terminated for that, but could we just wait till we get through this this joint commission certification process, and then we could let it go? Well, that's not acceptable. That's using an individual for your wants and needs, and then we terminate them at our convenience. So if a terminal offense happens today and we find out about it today, we should terminate them today or tomorrow after we complete a thorough investigation. Properly document all terminations, and you submit termination reports to your local UI agencies. Different state define misconduct just a little bit differently, but basically misconduct is defined as an act that substantially deviates or varies from the expectations set by an employer. It could be deemed as a willful violation of employment rules and regulations, threats, insubordination, attendance. Those all in most states are considered misconduct. Even carelessness can be considered misconduct if that carelessness or negligence is to such a degree that it proved to be incapacitated. And I guess the word I'm looking for is it proved that a reasonable individual would have known that a bad outcome would take place if we did it that way. So an example would be carelessness, that a negligence that would be misconduct is I had an employee who was changing light bulbs, and he was standing up in a rolly office desk chair. Okay, so a reasonable person would know that this thing has wheels on it, and if the wheels are not locked, and if no one is holding and supported, then bad things can happen. So in this situation, bad things did happen. The employee was separated for gross negligence, and we won the case. Of course, now we still had to play workers' comp. Workers' comp is a little bit different. Let me stop just real quick. Are there any questions at this point? Any questions before I move forward? Are there any questions in our chat? David?
I'm looking here. Let's see here. I do not see any participants asking any questions right now.
Okay. All right. Well, we will move on. If you have any questions, you can definitely put them in the chat. You can use the raise your hand feature, or you can hold it to open up all the mics and you can ask your questions at that particular time. Voluntary quits is the next issue that we see the most. There are probably more employees voluntarily leave their employment than are discharged. However, most of your voluntary separations do not lead to unemployment claims. For the most part, if an employee voluntarily quit, most of the time they're going to another job, so there's not a compensable separation for unemployment purposes there. But there are some situations that if an employee leaves and it's considered good cause, then they can be paid unemployment insurance. I will tell you that it is a little bit more difficult to draw unemployment if you quit your job than if you're involuntarily terminated. That's because in discharges or involuntary terminations, the burden of proof is on the employer. The employer has to show that they followed their rules, they warned you that the actions were inappropriate, and therefore they bear the burden of proof of providing that your separation was due to misconduct. In voluntary quit situations, the claimant or the former employee is the one who bear the burden of proof of showing that they had good cause for leaving. And these are just some of the things that would constitute good cause for quitting a job. I can't do the job because I'm ill or injured. Workplace harassment that goes unabated by the employer. So if I'm an employee and I report that I've been harassed on the job, the employer takes no actions to rectify that situation. And ultimately I quit because of that harassment continues, that could be deemed a voluntary quit with good cause and would be compensable by the unemployment insurance agency. The same is true with a hostile work environment. If the work environment is dangerous, is precarious, the employer is not taking safety protocols and puts me at risk, then that could be good cause. The other thing that we see some is that employees quit because the employer has asked them to perform a duty that is either illegal or immoral. And if you refuse to do that and quit because your constant pressure is put on you to do that type of action, then that could be deemed as good cause for leaving work. We always request our customers and clients to get a written resignation. So if an employee comes and say, hey, look, Curtis, I'm going to be leaving the job in 2 weeks. This is my notice and I'm leaving. I will say, hey, I am so sorry to see you leave, but could you please reduce that, your resignation to writing? Give me a written resignation letter and we'll keep that in file. And why do we do that? It's because that people's memories and their statements change as time go on. So what was a verbal resignation when they were leaving your job becomes, I was fired by Rhonda for no reason at all. She never gave me a reason. She just came to me and told me I was fired. But if you have a written resignation, you could blunt that particular type statement. The other thing is it's important to recognize resignation periods. Most of our companies have policies and procedures that require our employees to give us a 2 or 4 week notice, depending on what positions they hold. So if an employee abides by our policy and gives us a 2 week notice, and we say, hey, thank you for that resignation letter, but you can go today. We're not going to allow you to work out your notice. We're going to accept it effective immediately. That's fine. That's within your rights. However, many unemployment agencies would consider that a discharge because the employee followed your policies and procedures and you did not. So if you do not pay out that written notice, or do not pay out for the notice period, many state agencies are going to consider that as a discharge. And when an employee files a claim, they will receive benefits. So we've talked about the initial investigation, the issues that are generally investigated during that period of time. So after that is done, the claims adjudicator will issue a decision, a determination, saying that this person is entitled to receive unemployment insurance benefits, or based on the separation, they are disqualified from receiving unemployment insurance benefits. Now, after that decision comes out, most states give you 14 days to appeal that to an administrative law judge. Some states give you 21. So If you disagree with a decision that's come out, we recommend that you appeal that decision. And when you appeal that decision, you will get a notice of the date, time for the hearing. 90% of them are done by telephone today. So in telephone hearings, we have to make sure that we have the right witnesses to give testimony. Firsthand witness testimony is the best. It's the most reliable and is the type of testimony that more often prevails in an unemployment insurance hearing. So if I had a person who actually saw the incident, reported the incident, or terminated the employee for the violation of policy, that's my best witness. What often happens is that these people write up documents, submit them to human resources, and the human resource director or the company executive will testify at a hearing based on the documents. That type testimony is less reliable because it cannot be questioned, the documents cannot be questioned, and the employee does not have the ability to cross-examine documents. So if you provided something based strictly on the documents and I asked you a question about it as a claimant, your answer would be, well, I wasn't there. This is what the documents say that I have. That testimony is less reliable. Whereas if you were the person who actually observed the incident or the cause of termination, then if that question is asked, you say, well, yeah, I did see her do that. This is what she did. This is a policy that was violated. And that's why we terminated her. So that's why we have in-person testimony is much more, firsthand testimony is much more important. Please have all employees, if you have handbooks, have your employees sign the acknowledgement statements that they understand and are responsible for abiding by the policies that you've put in place. I was just checking my time. If there are any exhibits that you want to submit for the hearing, you have to submit those in advance, and those have to go to both the administrative law judge as well as to the ex-employee or the claimant. So if I have written warnings that I want to make part of the hearing record, if I have photographs of a person sleeping on the job that I want to be made part of my hearing records, I have to send that information in prior to the scheduled date of my hearing. And I have to send a copy of that to both the client as well, the claimant as well as the state agency. The other thing that we like to tell employees is it's always important to have a grievance or an appeal process within your organization, because if you have a grievance process, the employee did not avail themselves to that grievance process, that generally goes in your favor at any administrative process, be it at an unemployment hearing with EEOC or other work-related grievances filed by employees. If you have an internal process, they fail to avail themselves to that process, then that works towards your favor. Okay. Okay, let's talk about the really important part. That's the claims process. After you go to the ALJ, give your testimony, they will issue a decision. If you disagree with that decision, you can appeal to the board. If you disagree with that decision, you can appeal to the courts. Now, in most states, the agency board of review only reviews testimony from the referee's hearing and documents from that hearing. They generally will not have another live hearing for you to participate in. So it's important that you establish a really good record at your ALJ level, because that record can be subpoenaed by other courts. It can be subpoenaed by EEOC. So if we're going to do a hearing, we're going to make sure that we create a very good record so that anybody that reviews that record will understand clearly why that person is terminated and why we believe that they were justifiably terminated. Okay, let's talk about employer chargeability. Remember my first fact at the beginning? Employers support this system. Employers contribute the money that lead to payment of benefits. Employers contribute the money that support the staff, building, facilities, supplies that your state UI agency have. So you pay for all of that, and you pay for it through your taxes. You know, I don't know about you, but I like to pay as few taxes as I can. So I take advantage of all my opportunities to save myself taxes. And we'll talk about how you as an employer can save a little money on your unemployment insurance taxes as we move forward. In the state of Tennessee, there are basically two types of employers. There are what we call reimbursable employers, and there are rated or contributing or tax-paying employers. I don't care how they say it, a rated employer means that you're gonna pay taxes. So let's talk about the difference. You can become a reimbursable employer, and what that means is that you're basically self-insuring your unemployment benefits, meaning that as an employer, you will not pay any money into the unemployment insurance system unless a former employee of yours files a claim and then draw benefits. Only then will you be required to pay money into the system. Of course, with that privileged status also comes some downfalls. In many states, if you're a reimbursable employer and that person is paid, you have no rights to a none charge, meaning that if they get paid, you have to pay it back. If they quit, if they stole, if they fought, if they ultimately are deemed eligible for unemployment benefits, you have to pay it. And I have had quite a few reimbursable employers that become very upset. And my favorite one is the guy who stole a school bus. One of my clients was a school district, and they employed a preacher. And so the preacher was a bus driver, and they allowed bus drivers in this rural area to take the buses home. So the bus driver would, on Sunday, take the school bus, pick up all of his parishioners and bring them to church, would then drop them back off after church. During revival, or if they had what they call meetings where they visited another church, he'd load up his parishioners and he would drive them to the next church location using school bus, using the school's bus, using the school's gas. And so when they found out about it, they terminated it. He filed a claim for unemployment, was initially denied. But the preacher went to work for another company, worked for about 3 months, and was laid off. So during that 3-month interim, he had earned sufficient wages to mitigate the original disqualification and was deemed eligible to draw benefits. So when he started to draw benefits, that school district, where he earned all of his base period wages, was required to pay back that money. Well, you know, my superintendent was highly upset that he would be required to pay money to and he did this, a preacher who steals my bus and gas to promote his own goods. So as a reimbursable employee, you cannot be non-charged. If that person is ultimately deemed eligible to draw benefits, then if they draw, you pay. But if no benefits are drawn, you do not pay benefits. A rated employer pays taxes to the state unemployment agency, and they pay taxes on a quarterly basis. Whether you have a claim or you do not have a claim, it does not matter. If you're a rated employer, you will pay taxes every quarter. The amount that you pay is dependent on how well you manage your unemployment compensation benefits. And let's talk about that. So these are some ways that you can protect your tax rate. Implement good employment policies and practices. Ensure that the way you run your business is according to best practices in your industry. Often, if you have good business practices, if you have great employee benefits, if you have good policies, you never get to the unemployment insurance agency. Employees stay longer, they work harder, and you're not even faced with having to try to mitigate unemployment. However, if you do, you will be ready because you have documented, you've reprimanded, you've created policies and procedures, you set expectations, and you have managed to those expectations. So if a termination occurs, you're ready to defend it. Train both your supervisors and your employees, especially your supervisors. They're your frontline eyes and ears and your hands and feet. They represent your company, and if they do a bad job in managing employees, bad things happen both with unemployment and other workplace litigation. Proactively avoid layoffs. So, we could not prepare for COVID. It hit us so fast that many employers were caught off guard. Everything shut down. So we could not proactively avoid the layoff. But if you can see downturns in your economy, or if you can predict cycles in your business, then you can predict and manage towards not laying people off in mass. If you can do that, you save your unemployment. If a person is laid off, they automatically qualify for benefits. Terminate employees timely and according to your policies. We've talked about that a little bit. Submit your termination reports to your state agencies. Respond to all UI forms in a timely manner. If you see charges that you don't believe are correctly, protest them, fight them, appeal them, write your letter to the state agency. And if you have an unemployment insurance hearing, prepare proactively to win that case. Do your homework, prepare your witnesses, do mock hearings. And that's what we do with our clients, especially if we have a new supervisor that's never been in a hearing. When we're doing prep work, we put them through a mock hearing. We ask them some really hard questions. Sometimes they're sweating. They're like, are they gonna ask me that? So yeah, they're gonna ask you that and more. So be ready and don't fold under the pressure. So why does it matter? So let's look at some of the Tennessee numbers that we have here. So Tennessee unemployment wage base is $7,000. So every taxable employer pays taxes on the first $7,000 that every employee earns. How much taxes that you pay on that first $7,000 is up to you. So the example that I've set out in this slide, it uses 100 employees as our base. The minimum tax rate for the state of Tennessee is 0.01%, and that's a really low rate, one of the lowest tax rates in the country. Most tax rates start at 0.2 or 0.4, 0.04, 0.2 or 0.04, but a 0.01 is a very low tax rate for Tennessee employers. So in this example, you have a 0.01% tax rate, and you pay that on the first $7,000 of your 100 employees. You're going to be paying 70 cents per employee and $70 for the entire year based on a 100 employee base. That's really low. New employee rate. So if I start a company in the state of Tennessee and I get rated by the state, my new employee rate is 2.7%. So at a 2.7% rate, I would pay $189 per employee, or $18,900 overall. But can you see how tax rates make a difference? I think that I looked and the average tax rate for a Tennessee employee was at 193. So if we look at that as a 2% tax rate, then you would be paying $140 per employee, or $14,000 for 100 employees if you had an average tax rate for the state of Tennessee. Now, Tennessee's maximum tax rate is 10%. So if you've not done a good job, if you had a big layoff and your experience has raised your rate to 10%, you are paying $700 per employee, or $70,000 per year for your 100 employee base. So depending on how well you manage your taxes, you can pay $70 a year or $70,000. That's a huge difference. And I want to remind you that that $70,000 comes off of your bottom line. And the other thing that I have to tell employees is that not only are your claim charges applied to next year's tax rate, but in Tennessee, it is calculated in the next 3 years tax rates. So it would be impossible for you to go down to a minimum rate for 3 years if you get one claim paid. It would affect your rate for 3 years. And one of my favorite examples on that is we had an employer that we had to fight because they had a minimum rate, and minimum rate at that time was 0.02%. And they had one claim file. Well, $1 of charges will increase your rate 0.01%. So this employee had a $1 claim charge, and their rate went from 0.02 to 0.03. It's like, and it was going to be at 0.03 for 3 more years because $1 was paid. This was an employee who had 2,000 employees. So that 1% charge would have cost them a lot of money over 3 years. So what we did is we investigated that claim, and we realized what had happened. This person had filed a claim the previous year. I think that was in 2017. They had filed their original claim, had been disqualified, and my customer had been none charged. Well, this person moved to the state of, I want to say Alabama. Might have been Louisiana, I can't remember. But they moved to another state. And in 2019, they filed another claim. When they filed that second claim in 2019, my customer had a small amount of wages that was used in the calculation period. Because this was filed in another state, they did not continue my non-charge. So we had to protest and file an appeal with that other state to mitigate a $1 charge, which resulted in, I think we had calculated we were going to pay for that $1, $72,000 in taxes. So $1 can make a difference. Okay, we're on the home stretch, so I have about 2 minutes, and then we will see if you have any questions. So this is how COVID has impacted UI. There was a record number of UI claims filed in March of 2020. There were 3.3 million people filed unemployment claims that week. More people than have ever filed claims in 1 week in the history of unemployment. The month of May 2020 had the most unemployment benefits paid out ever in 1 month. They paid out $23 billion in unemployment insurance benefit in the month of May. In 2020, there were $144 billion paid out in unemployment insurance benefits. Now, how does that affect employers, and how does that affect trust funds? So the taxes that you pay as an employer goes into the state trust fund. So taxes that you pay go into the Tennessee unemployment insurance trust fund. From that trust fund, they pay unemployment insurance benefits, and they pay what they call administrative costs. That's for staff and systems to operate unemployment insurance agency. So in 2018, if we combine the trust funds for all 50 states in the country, it was at $66,560 million. In 2019, we have had an increase because unemployment was relatively low in 2018, 19, and then 20 hit and they went crazy. But we had an increase, so the trust fund, combined trust funds for 2019 was $75,677 million. That was an increase of over $11 billion. Now look how 2020 hit us. The combined trust funds for 2020, and this is effective December 12th, that's the last number that I could find, The trust fund for all 50 states at that point was $24,918 million. That's a drop of more than $50 billion. So we're paying out much more money than we're bringing in right now. And remember, unemployment benefits are supported by employer taxes. So if you're running at a deficit, if you're paying out more benefits than you're receiving in taxes, something has got to give at some point. And we'll talk about that in a minute. Now, Tennessee did a better job with their trust fund than probably 80–90% of the states in the country. If you look at your 2018 trust fund was $1.175 billion. In 2019, it increased to $1.273 billion. If you look at 2020, your trust fund only dropped about $117 million. So it was still at a really healthy $1.156 billion. And I was curious about that. I was like, I mean, I have seen states that go from 11 billion on the plus side to 5 billion on the negative side in their trust fund. So I was trying to figure out, how did Tennessee manage their trust fund so well while all these benefits were paying out? So let's look at that at the next slide. Yep, that. So in Tennessee, most states provided tax relief or relief from charges from March of 2020 through December 31st, 2020. In Tennessee, employers were relieved of charges from March through September. You began paying charges based on what they call COVID claims filed after October. So money kept coming into the system because those charges were not relieved. Employers were paying them. Also, your governor, Governor Lee, used, I think it's about $600 million to put of CARES Act funds to put into your trust fund. There is a regulation in Tennessee that if your trust fund falls below 1 billion, then that is an automatic trigger for taxes to increase on all employers. In reading the article from your governor, he thought that if he had not done that, then taxes on employers could have increased about 300%. Now, that's probably a little exaggerated, but I am sure the taxes would have increased by 50 to 60% on all employers had you dropped below your $1 billion threshold and that automatic tax generator kicked in. So that's how you did it. And I think it's a really smart idea. I think it probably saved employers much more money than some of the other states that we're doing right now, because in my states and in 3 other states that I work with, they're looking at increasing employer taxes across the board. They're looking at providing what they call a temporary assessment on employers to rebuild trust funds. I have not seen anything in consideration for Tennessee at this point to do such drastic measures to rebuild your trust fund. And that is a benefit to your state officials, that they had the foresight to protect you as employers from these huge tax increases. A couple other things real quick. The thing that's really blown up is identity theft claims have exploded. We have more identity theft claims in 2020 than we had in 2014, when we had a huge identity theft ring that was just ravaging the country from unemployment insurance benefits. The other thing we've seen with COVID impact is it's a lot harder for some employers to get employees back to work. You know, a lot of my customers in healthcare, a lot of it in manufacturing. And so when the government was giving $600 weekly enhancement check, we had some nurse aides that were earning $700, $800, $900 a week in unemployment insurance benefits. So when my employer would call them and say, hey, look, We got work. You can come back to work. They're thinking like, I only earn $400 a week working, and I'm getting $800 to stay at home. It's pretty much a no-brainer. I don't think I'm coming back right now. I'm still afraid that me and my family might catch COVID. So it's very difficult to bring employees back to work. I don't know if any of you have experienced that or not, but we found that one of the impacts of COVID. I'm running out of time, so I'm gonna get to a stopping place here and take your questions. So Ken or David, if you want to open up the mic to see if we have any questions, I'd be glad to entertain any questions. I went through that pretty fast, and I apologize if I missed something that was important to you.
I don't see any in the chat box. And Ken, are they able to open up their phones now, or can we open up their mutes to see if they want to just verbalize maybe a question?
Yeah, David, I open everybody up.
Okay, so feel welcome to. I'm still showing they're muted on my side here. I don't know why, but
I think they can unmute themselves. They have a question.
Okay. You could they unmute themselves. I see.
Mhm.
Well, feel very free to unmute yourself and ask any question you might have.
Okay.
All right.
Maybe we did a good job, David. I don't know.
There you go. Well, there's contact information there for those who might think of that question later. They're certainly welcome to reach out to you on the screen. They can see how they can do that.
Okay. And we will send this slide deck over to David. There's one slide that I'll need to correct, and I'm gonna do that before I get that to you, David and Ken, and you can send it out to all of your participants.
All right, we thank you. This ends our webinar today. We have, for those that may want someone else to participate, we'll have another one actually tomorrow. And if you're watching this as a recording, we thank you for watching this recording, and all this current information, this contact information be current for you that are watching a recording. Thank you so much.